Adeeb. I am second year BBA student in AMAL College. Today I am going to discuss about requisites for a valid ratification. 10 important requisites of valid ratification. The requisites of valid ratification are as follows. First point, the principal should be in existence. The agent must expressly contract an agent for a principal who is in existence and competent to contract. Nobody as an agent can bind by contract a principal who does not exist at the date of the contract. Thus, a company cannot ratify or adopt a contract which was entered into by the promoters on its behalf before its incorporation. Second point, the agent must have purported to act for a principal. A person can ratify only that which is purported to have been done for him and cannot ratify that which is purported to have been done for somebody else. Act done by a person on his own account cannot be ratified. Only when an act is done on behalf of the ratifier, such act can be ratified. Third point, the principal should have contractual capacity. The principal should have contractual capacity both at the time of the contract and at the time of ratification. This is because the principal can ratify an act by the agent provided he himself could do the act which he purports to ratify. Thus, when the minor was not in a position to give authority at the date when acts were performed, he cannot subsequently ratify these acts. Fourth point, the act should be capable of ratification. The act to be notified must be lawful and not void or illegal or ultra virus in case of a company. Accordingly, the shareholders of a company cannot ratify an ultra virus contract made by the directors. Then fifth point, principal should have full knowledge of material facts. Section 198 of the Act states that no valid ratification can be made by a person whose knowledge of the fact of the case is materially defective. So, the principal should have full knowledge of material facts. Sixth point, ratification cannot be partial. A contract cannot be ratified partially. This provision is contained in section 199 of the Act, which states two parties ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of which such act formed a part. Seventh point, ratification should be done within a reasonable time. The ratification becomes valid only if it is made within a reasonable time after the act to be ratified is done. Eighth point, ratification should not cause any damage to a third person. A ratification is not valid if it causes some damage to a third person or terminates any right or interest of a third person. The ninth point, ratification must be communicated. There can be no valid ratification of an act unless it is communicated to the other party. Ratifier cannot keep his thoughts to himself. Then 10th point, ratification relates back to the date of the act of agent. Ratification relates back to the original dating or making of the act or contract. It has a retrospective effect. It amount to previous authority. It places all the parties in exactly the same position as they would have occupied in the case of a precedent authority.